Greetings from Toledo. I'm Dave Perdue, the Trademark Wahoo, and we're going to talk a little bit now about trademarks that are merely descriptive or so highly descriptive that they're not eligible for registration on the principal register. The theory here is that we don't want trademark owners to pull descriptive words out of the language and make them unavailable to competitors who would have a need to use those terms in connection with describing or promoting their services. I have two cases to talk to you about, and one involves an application by a law firm to register the corporate law group for, wait for it, legal services. The application was filed and examined, and the examining attorney said that, yeah, no, really not, because the corporate law group is used by several firms, many firms, especially big firms who have a group of attorneys within the firm that practice corporate law. And we can't take those terms out of the language and make them unavailable to other law firms that practice corporate law and have a group of attorneys within the firm that specialize in that. The law firm argued against the refusal and was not successful, so the firm filed an appeal at the Trademark Trial and Appeal Board, where the case was heard and decided against the law firm. The board went so far as to hold that the corporate law group was a generic term for providing legal services. Now, corporate law is just a subset of legal services. I practice trademark law. Not so much at all with corporate law. And one of the arguments that was put forth was that the corporate law group isn't generic for trademark law or family law or personal injury law. And the board said, well, that really doesn't matter here because, generally speaking, if a trademark is a generic term for the services listed in the application or even a subset of those services, then the mark is generic and it's not eligible for registration. The second case involves an application to register the craft beer attorney for legal services. The applicant was not a law firm. The applicant was an individual attorney, and guess what kind of law she practices? Okay, you got it. She practices law and represents craft brewers. Her application was filed and registration was refused on the ground that craft beer attorney merely described the services that she provided. Her response to that involved evidence that she had been using this term exclusively and continuously for a period of 5 years, and the term no longer merely described her law practice. It had acquired a secondary meaning. It was now performing the function of a trademark to indicate and identify her as the unique source of her kind of legal services. The examining attorney reviewed the evidence and accepted it and approved the approved the application for publication of the mark for opposition. Well, it drew quite a bit of attention, and no fewer than 13 law firms and individuals filed formal notices of opposition to her application to register the craft beer attorney. Those were only filed a few months ago, so it will be quite some time before the proceedings come to a conclusion. I'm thinking that lawyers especially would be sensitive to the problems that can arise when very descriptive or even generic terms are used as trademarks, and the problems that are going to come up in the Patent and Trademark Office. But there you go. That's all I have for this session. But remember, you'll do better in Toledo.